Again, I'm Doug Farquhar. I work for a group called the National Conference of State Legislatures. And the only reason I want to bring this up real quick is to let you know that we are not, I really don't have we don't have a dog in this hunt. It's kind of about the best way to put this. We don't get any sort of benefit or attraction or anything like that if we do this. What my job is, if a state legislature wants to adopt the Model Aquatic Health Code, I'm here as a resource to let them know what the issue is behind it, why they may want to adopt it, what are some of the ramifications of it. We are a national organization. We actually are funded by all 50 state legislatures and actually get some money from Quebec and from Alberta and the country of Scotland. I've just recently discovered they are part of our group. But we're a national resource to help state legislators adopt certain policies and understand what's going, what other states are doing. So, but I wanted to really bring this up just for the simple reason that I wanted to let you know that no, we don't have a benefit on this one or anything along those lines. We do this as part of our policy work with state legislatures. Now, what I was asked to come speak about today is not the Model Aquatic Health Code, not the American Disability Act, but what happens when a state adopts such a program and what happens when a state does not adopt such a program. And the biggest issue we have out there is what are the liabilities out? What's the liability and risk for operating a aquatic venue? First of all, and I don't really need to emphasize this with this group, but aquatic venues are dangerous. Things happen at aquatic venues. People get, not only do we have drownings, we have slips and falls, we have chemical incidents where people get harmed by the improper use of certain chemicals. We have certain public health threats. These are inherently dangerous. These things happen. It's just part of having an aquatic venue. So, who can sue you if something happens? How are you protected? Well, if the venue is available to the public, if it's available to paying patrons, meaning even if you do have a country club, you can get sued. You can get sued by trespassers. Basically, you have no protection whatsoever. You have a swimming pool, you have a fence, someone climbs over the fence, they have a few drinks, they slip, fall in, they drown, you can get sued. You may win the case, you still will get sued. So, how do you limit liability? Well, the question on this one is, you can always put up a sign. One of the first things they'll say in a court is, do you have signage up? How do they know they were trespassing? Well, one way is they climbed over a fence. But another way is that they have a sign up saying, this is private property, do not enter. This is our property of whatever. Or, this is the private property of the city of Lexington. We are not, it's after hours, so therefore, you do not have the right to come in. You are trespassing. So that limits your liability. The other common one we see is no diving. Diving, as you know, is a very difficult, it's a very dangerous activity. People hit their heads on the bottom, and all of a sudden we have a problem. For the pool owner, for the patron. One of the easiest things to do is to put up a sign that says, no diving. Now, is that going to prevent people from diving? No. Taking away diving boards, does that take away people from diving? No. They're still going to do it. But if you have a policy in place that says diving is a problem, that we do not allow it, then you've got a little bit more protection when you end up in court. I'm going to talk about getting into court in just a minute here. Supervision. This is another major way of limiting your liability. If you have a lifeguard on duty, you have someone there, you have an operator to say, you cannot dive here. You are not allowed to drink on our premises. You are not allowed to let that baby go in the water without a swim diaper. All these things limit your liability. Now, as you know, in many situations, people can't afford to have a lifeguard. No lifeguard on duty. That's just, you know, part of the situation you have to deal with, which means it's unsupervised. So is that going to increase your liability? Is that going to increase your risk? Absolutely. But it's not something that you can go forward with and just simply say everybody has to have a lifeguard on duty, or that it's the policy of our company to have a lifeguard on duty if you don't have the funding to put that into place. Actually, that would be a limitation. Is if you have a policy in place that says we have to have a lifeguard on duty, and something happens, there was no lifeguard on duty, the lawyer deposes your policies, and they can simply say they weren't following their policies. They were supposed to have a lifeguard on duty, therefore they are liable. Restricting access is another way of limiting liability. As many of you know, I'm sure there's probably, in a very rare instance, that you would not have some sort of fence, gate, guard, enclosed area to keep people out of pools. There's a reason for that. One reason is, obviously, you just don't want people messing with your pools, but on the other thing, if you don't have a fence, it makes it very difficult to say that these people were trespassing. So that limits your liability. And signing away rights. This one is one of those things which occasionally works, occasionally does not work. But if you have a private country club, you fill out the membership. One of the things you sign on there is, I'm not going to sue the pool, I'm not going to sue the country club in case something happens. Now, will that hold up in a court of law? Yes, no. There have been times where you have a contract in place and you say, yes, we have the signed signature here, they agreed to it, they agreed to the risk, they went swimming anyway. They can come back and say, yes, but they weren't following their own internal policies, or they weren't following the policies of the city of Lexington, or even more so, they weren't following the Model Aquatic Health Code, even though it has not been adopted by this jurisdiction. That will give them a counterclaim to say, we got a new standard out there, it's been brought forth, and our company or our country club was not following it. Now, I'm not going to say they're going to win. I'm saying that they can bring the case forward.